Okay, so again, I'm really honored to be here. I'm really excited and interested to talk to you about a couple, at least two kind of big legal issues and claims that I know a lot of people have questions about, Clemency and the new Senate Bill 819. My name is Eliza Kaplan. I'm a law professor at Lewis and Clark Law School. I am the director of the Criminal Justice Reform Clinic. The clinic does what I call back-end work, where we work on cases and on reform issues, legislation, etc., that affect the back end of the criminal justice process. So, for example, we do clemency, we do parole. We have a program for incarcerated youth through Oregon Youth Authority. We do back-end, some wrongful conviction, forensic science stuff. And over the last few years, and especially this year, we've been very involved in the non-unanimous jury issue. And we work directly on cases and represent folks, but we also are very involved in legislation, in writing a brief, appeal, things like that on the issues that affect our clients and people like our clients. So that's who I am. And the reason I reached out to the Department of Corrections and some of you in this room and others about doing this kind of presentation is because the clinic gets, as you can imagine, hundreds of letters from AICs all over the state. And it felt like there was a lot of misinformation out there about the clemency process, which right now is urgent, as I'll talk about and many of you know. And then, obviously, in the last few months, we've also gotten tons and tons of letters asking about this new law. And I just think it's important that we have ways to communicate where you can really hear at least my opinion or what my clinic's doing on some of these important issues and sort of set people's expectations properly. I know the rumor mill can often create lots of drama, and we don't want that. So that's what we're here to do today, and I want to start by talking about clemency. And I thought I would I know some people had submitted questions, but I thought what I would do is kind of do an overview, and within that answer a lot of the questions I saw, and then kind of go through some of the other questions that were on the list. And then I'm going to pass it over to Nathalie and Michelle to talk a little bit more on the DOC side of things with regard to clemency. I hope that all sounds okay. Great. Okay. So first of all, for people who might not know, what is clemency? Clemency it's really a power that all governors and the president have. It's an executive power, and it allows the executive to commute someone's sentence and pardon someone's conviction. Those are the two main things. Also, the power can be used for reprieve. For commutation purposes, that is what most AICs are interested in. The commutation power allows our governor to change your sentence, basically release you early, lessen your sentence in any way she wants, send you to the parole board early, anything, right? And so any lessening of your sentence is what a commutation is. And so, over the last few years, I just want to put it in perspective, Governor Brown has slowly moved more and more towards granting clemency commutations. I think often clemency can be very political, which is unfortunate because historically it was used very often. But I think like everything else in our criminal justice system over the last 50 years or so, there's so much politics around it, and there's so much aim towards punishment that the idea of granting clemency sort of drops out of favor. And here in Oregon, our governor over the last 3-4 years has sort of been warming up to the idea. She's absolutely interested in clemency. She's very understanding of racial injustice, mass incarceration, juvenile brain science. She really has a very enlightened perspective on all of these things. But I think it's taken her years to sort of get to a place, and maybe because she only has a little less than a year and a half left on her governorship and she cannot run again, it's speeding up, and her interest and desire to grant clemency has increased. So just to give you an idea, after every legislative session, the governor has to report to the legislature on the numbers of clemency cases that she's granted. She submitted that report in the end of June. So over a 15-month period, she granted 33 individual pardon cases. Pardons are for the people who are already done with their sentences, and the governor is taking their conviction off their record. And then 32 commutations, where she released people from prison and lessened the sentence, or she sent them to the parole board, or she got rid of their post-prison. So a total of 65 clemency cases were granted. She also granted, as many of you know, different groups of people based on medical vulnerability because of COVID. She also did a group of firefighters. She commuted a year off people's sentences. So she did a number of groups, and then she did 65 individual clemency cases, 32 were commutations. So, that number those numbers can be looked at differently. The overall numbers, or over 1,000 people, were released from prison because of Governor Brown's clemency granted. So, but I think it's really important that folks know that prior to this last 15 months, she had only granted a handful of commutations. And so I know in our clinic, I think we had 4 or 5 over the couple years before. And then this last year, we had over 20 commutations. So, and a bunch of pardons. So it's heating up, and everyone should feel excited and interested and be thinking about, am I a good candidate for clemency? So with regard to that, what is a good candidate for clemency? Well, I want you to know I reached out to the governor's office. I know what I think is a good candidate, but I also reached out to the governor's office to get some of their sense to make sure I was in line with the things I'd be telling you all. And a few things came up from them. Number one, they're really looking at people who have served at least half of their sentence. And they said, with all the excitement happening, they've been getting petitions from people who have served, a year or 2 and are making these cases. That's not the kind of case they're interested in. And by the way, this is what they've said. So people who have served more than half their time, people who have remorse for the crimes, and people who can talk about the crime. They said it was really important that people were able to talk about, who they were at the time of the crime, and provide details of the crime. To them, I guess that's a way for them to see where someone's at with communicating about, their behavior. They also wanted to be clear that people do not need the clinic or a lawyer to represent them. In fact, they take it very seriously, the equity issue, that not everyone can have a lawyer. But they also feel like it's important that what you're submitting is more than just the basic application. So I'll just tie in that one of the things we recommend, and we send out materials, many of you have probably received it, is we recommend that people fill out the application from the governor's office in a lot of detail, and then also address everything else in another document, maybe the Dear Governor letter, or they can then walk through a lot more about their past, you know, your upbringing, if that's relevant, your addiction, if that's relevant, the crime in more details, how, you know, your programming, and then you can put it all together, and that can be your petition. So the application alone doesn't really allow you, if you just fill it in, to really get to a lot of the things they want to learn about you. So they want to learn about your programming. They want to learn about your education, about your employment. They want to know about, I'm going to use this in quotes, your rehabilitation or your transformation. They want to know how you've changed and what it all means. So you doing that in a letter form along with the application, and you can just sort of address all of these things, it can be really a good way to do it. They also want folks to have a pretty detailed, what I call a parole plan. They want to know, what are your plans if you're released? Now remember, one of the considerations for the governor is public safety. So what are you going to be doing that is going to make the governor feel comfortable that you're going to be safe, the community is going to be safe, others will be safe, your family will be safe? That means having a plan. That means thinking about what job you might do, where will you live, who will be your support community. If you're into religion, will you go to church? Which one? If you have an addiction, where are you going to have meetings? Who are the people in your life that will support you? All of those things can be discussed in a section of this letter about your plans. Just keep going here. I know Natalie is going to talk about the letter process. Outside of the DOC letter process and getting people, DOC to write you letters, people always ask, why does the form say no family letters? I think you should have letters from anyone that knows you really well, anyone that can speak to your transformation, anyone who is going to be your support on the outside, whether it's through employment, housing, or love, or whatever it is. And a lot of times those are people's families, especially people who have been incarcerated for a really long time. So I think it's totally fine. It's not about having the most letters of support. It's about having really thoughtful letters serve a purpose. So if your family members or the people who can really speak to your transformation, it's fine to have family members. So you'll want to include letters of support that address all of these different points. I want to talk a little bit about, one other thing the governor's office mentioned. They're no longer doing clemency cases based strictly on medical vulnerability. So medical vulnerability, like with COVID, so medical vulnerability might be one of the things that makes you a good candidate, but they really want to see all of this other stuff as well. Okay, they definitely said that. What happens once you file and serve your petition? It will go to the governor and it'll go to the other people required under the law, which is the Board of Parole, the Department of Corrections, the DA's office in the county where you're housed. So for the folks at OSP, you'd have to send one to Marion County. And the DA's office where you were convicted. And if you have convictions in different counties, they all have to get one if you're asking for computation on those convictions. Once your petition gets to the governor's office, they go through an internal process of, basically logging it in. And you will get a letter from the governor's office that says something like 2 sentences that says, we got it, and we can't act on it for 30 days, and you're not going to hear from us for about 6 months. And that's just, everyone gets that letter once it's logged in. The governor's office then, through the general counsel's office, starts to pull documents from DOC, from the DA's office. DA's office will spend time reaching out likely to the victims in the case and see if they want to weigh in some way. All of these documents will make it back to the governor's office till they have a full file. Then they will do their review, and eventually, if it's the review is a positive forward decision, it will go to the governor himself to review and make a decision. To be very clear, at this moment, this process is taking anywhere from 6 months to a year, right? And the reason is the governor's office has 304, as of a few weeks ago, had 344 pending, open cases, basically people sending stuff in. And almost half of those came since May. So, they're a small operation. They're aiming to review everything. They're also waiting on others to submit materials to them. So if the DA takes their time, then that's that. They're waiting and they're bugging them and they're, so it's a process, yes, is what I'm telling you. And so people should know if they've submitted and it's 8 months, it's not you necessarily. It might be, but it might not be. We have cases that are pending that one as well. We have cases pending for the year. So it's really important that everyone understands the time frame. If people are interested in clemency and meet the criteria that I just mentioned, I implore you to get your petitions done. And again, you don't need a lawyer. You need to, fill out that form and write that letter and gather all your stuff, because the governor only has until, I think, December 15th, 2022 to decide on clemency cases. And there's about a year, right, in the waiting. So that means everyone who really is serious about this needs to get it done soon. I just want to quickly address some of the questions that I haven't addressed yet that were on my list. What happens if the victim or the district attorney don't support? So I can only give you this information from our experience in the clinic. Obviously, if you have the victim of your crime supporting you and or the district attorney supporting you, it is much easier situation. But I've had many cases where neither has been true and we have been successful. I do not think every case is unique and the story is unique, but I do not think that automatically means that people are unsuccessful. I do think different district attorneys handle these cases differently. And so a lot of it might really depend on your county and your district attorney. Some district attorneys, if the victim is not supportive, then they won't be supportive. And they just say that. Some district attorneys, because the victim isn't supportive, they're really against it, or they're just really against it anyway. And in other cases, the district attorney might be neutral on the case based on what they've reviewed. So and others, they might be very supportive and write a beautiful letter. So it's really all over the place. And I would say that you definitely do not need either 100% to be successful. Obviously, if you have it, amazing, and only help. People asked about plea deal. Yes, of course. Anyone can apply for clemency based on any type of conviction, whether it went to trial or whether you took a plea. Can you reapply if you've already applied? Yes. If you never heard back, or you applied with a different governor, or you were even rejected and now your circumstances have changed or more time has passed, you absolutely can apply again. What if you have multiple convictions? Well, it's your job when you write your clemency case, if you're still doing time on any of your convictions and you want to be commuted out of there or to the parole board or lessen your sentence in some way, that you address the different convictions. If you've already finished serving time on, let's say, 3 of them and you're serving the last one, you're really asking for a commutation based on that last one. But when you're talking about your story, you're of course going to mention the others, and you're of course going to say, I already finished serving my time for those, and this is my last conviction, and I have 10 more years, and I'm asking you to release me now because of all your reasons, okay? So you're never hiding the ball, but you have to look at your convictions and see what specifically you're asking for. It's really important that you remember that the governor's office is going to look at everything, not just what you submit. So you want to be as upfront about any of those things. Clemency and immigration. So this one's more complicated. If you are not a U.S. citizen and you're interested in a commutation, you absolutely need to speak to an attorney. And the reason is because if you got commutation and you didn't speak to an immigration attorney, you could walk out of DOC and walk right into detention, immigration detention. And, nobody wants to do that. So really important that if you are not a citizen and you want a commutation and you're a good candidate, you need to speak to an immigration lawyer. What could happen if people do want it, you could apply for a commutation, walk out the door, and be deported. That's another option. If you want to be deported back to the country where you are a citizen, then it might be a good way to go, right? But if you're planning on staying in the United States, you absolutely need to speak either way. You need to speak to immigration attorney to look at your specific situations. It would be really difficult to think that you would have gone through all of this and got a commutation and then you'll go back to federal detention on the immigration violation. So that is more complicated, and I really think anyone in that situation should, find a lawyer, an immigration lawyer to speak to. What about detainers for probation violations, right? So some people, you get a commutation and then you have an open detainer at another court or in federal court. All of that can be dealt with, but you probably need a lawyer to do that, to look everything up, see what you have conversations. I can think of one example that the clinic had with our client who had an open detainer in another state. And while his case was pending, we spent time working with the DA and a defense lawyer in that other state to clear all of it up. So every case like that is unique, but it probably needs an attorney to look at that more specifically. Spanish. There are no forms in Spanish, but I will tell you what we do at the clinic, which is we have lawyers and students here who speak Spanish, and we ask folks to find someone in their family maybe that also speaks English, and we will work with people on the phone to help them put together an application. We can't say where we will represent you because we're kind of full right now, but we definitely can sort of navigate some of the language issues. And they should be in Spanish. And I do think that if you are really comfortable in Spanish or another language and you want to submit it in that language, it's on governor's office to try to get it translated, and I think that they might. So I think that I have covered everything that I have on in list I got, except for some of the DOC stuff, which I think Natalie or Michelle is gonna deal with. Anthony, does that sound right?
Yep.
Okay, I hope that was informative for everyone. And I know you're welcome. I'll take questions when they're done on any of this, and then we can talk about Senate Bill 819.
Commutation packets are available in the law libraries, and so you're able to pick it up from there. And if it's not available, just ask your legal librarian to get a copy of that and have it available. And so sometimes they could just run out in that moment, and so ask anyways, because they have them and they know where they are, and they can get those to all of you. One of the questions was which offenses do or don't qualify for clemency, and all offenses are eligible for clemency. Lee's already touched on the medical clemency being discontinued. So as you may recall, when the COVID commutations first started last July, it was anyone, the first round you needed to be medically vulnerable, has served 50%. And then they also then added in people that were 2 months to the door, and then that changed to 6 months to the door, and then that changed to 6 months to the door, but not eligible for STTL or AIP because those were other early release mechanisms. So there are no more names being added to that list of the COVID commutations, and so we get kites constantly asking about that, and so just know that the commutations that are available are the regular process that she was talking about, and not through the COVID process anymore. So one of the things that has been consistent, just for you to know, in the group commutations, meaning the COVID commutations and the fire crew commutations, is that the governor's office was asking us to really focus on those who had had good behavior, and how we define that as no major or no level 1 or 2 misconducts within the last 12 months. And so I think a good rule of thumb when you're looking at filling out your own stuff is to really taking a look at your conduct history. And if you do have a misconduct, you know, even if it was 10 years ago, own it, say what it was, say what you did, and say, you know, what the next steps were around that. And so so that they have that information, because they're going to get that information from us on a letter, and so it's best to have that in your application thing. So do you need to send the clemency packet certified mail and return receipt? No, it's recommended but not required, and it's in the documentations, but you need to send that to the Department of Corrections, the parole board, the DA, and the county you were convicted, as you already covered, and the county that you're currently in. So DOC staff aren't able to be listed as a character reference, and so what we're doing is having a letter again come out of my office that really can take a whole look at all of your activities and participation during your time in DOC, and so we're doing that one formal response for this process. But I really encourage you to reach out. Volunteers can absolutely be listed as references. The other programming stuff that you do within the institutions from outside volunteers, they can write letters on your behalf, and so certainly draw from those sources as well. If you're wanting to get a letter, if you're working with an attorney, your attorney is going to contact Michelle, and Michelle's going to do that process. If you're not working with an attorney, what we ask is that you ask a staff member at the institution that you're in to be kind of a reference for you to Michelle. So that staff person will reach out to Michelle and say, I'm working with this adult in custody. I think he would be, you know, I recommend him or her to be able to get a letter of support from DOC. And then with that employee recommendation, then Michelle will be able to take that and reach out to the appropriate people to get the information that she needs. We don't just have an adult in custody write Michelle and say, I'd like to have a letter. So it does need to come as from somebody who knows you in the institution, right, to be able to make that recommendation to Michelle on the behalf, and then she will prepare the letter for my signature. So anything else on there?
And I really do encourage you to work with staff and have them reach out to me. That's where the best letters are going to come from, is when you do have staff wanting to reach out on your behalf. Those are where the absolute best letters come from, are the ones that you've been working with. So I definitely do encourage that.
And just to be clear, the DOC letter of support is one letter, right? I mean, we're just writing a letter that and some of you already have the letters from my office that talk about your religious programming, your educational participation, your work participation. If you've had any misconduct and, you know, what that's been about. But really, you want to get all the other letters from out there, from volunteers and out there in the world of your people as well. And then certainly anything that you can do to really be able to have a solid release plan as well is really helpful, because some of the commutations that we processed, they are approved, but we can't release people unless they have a solid housing plan. And if that piece isn't there, then the adults in custody are, you know, still hanging out within DOC just because that piece isn't in place. Think I missed anything? Okay.
I got a quick
Yeah.
question. You want to cover this? That letter that we'll get, the reference letter, will that come to us and then we'll turn it in with our packet, or do we have visibility on that letter itself? The DOC support letter? Or does that just go straight to the governor?
So the process is that you will go ahead and submit your clemency packet to the governor's office. I will confirm that that clemency packet has been submitted, and then I will work with the DOC staff to get all the information for the letter. I will reach out to different stakeholders like religious services, your counselor, all other your work supervisors, and then I will send that letter directly to the governor's office to be included in your packet.
Okay.
Yes.
So it doesn't come to us?
It doesn't. It goes straight to the governor's office, and we want to make sure that you've already submitted your clemency packet at that point so that we can be sure it's not being turned in 5 years later where there could be other information that would have been included on that letter. So we send that directly. If you're working with an attorney, though, we send the letter directly to the attorney, and they're able to then include it with the packet upon filing.
Okay, thank you.
Okay.
And I just want to add to that the letters are great, and they all say at the bottom, we hope you will support this clemency petition. So even though I know that people feel like they want to maybe get individual letters from some DOC staff, there's also something really nice about the Department of Corrections just saying, we support this. And I think the governor's office takes that seriously. That's my opinion. And the letters are very nice, and Michelle works very quickly. So should we do some questions on clemency?
My name is Cornelius Davis. My question deals with race and systemic race. How does a person address the reality of the systemic racial and social injustices within their case without seeming like they're not taking accountability? Like, I don't want to seem like a crybaby or that I'm playing the black card or anything like that, but it's a real issue that needs to be spoken about. And how would I go about doing that without, you know?
Yeah, it's a great question, actually. First of all, I think the people reading these understand those issues. So I think that you absolutely should address them, both in a general sense, right? If you feel comfortable, in a general sense, talking about, mass incarceration in Oregon, or at the time that you were convicted of your crimes, how, more specifically for you, how your race may have played a part in your treatment, in you getting involved in a certain lifestyle. I mean, any and all of those things are part of your story. And the people reading these know that there's systematic racism in Oregon, there's historical racism in Oregon, and without question, and we have tons of data and information that our criminal justice system proportionately affects people of color, especially Black and Native Americans. So I think it's really important, and I think you can do that and also take responsibility for your behavior and have remorse. I mean, I always talk about my students, you can hold some skinny chant, you can have these parallel tracks, and certainly racism can be alongside the details of your crime and, your rehabilitation and your remorse and all of that. It's not about being a crybaby, it's about facts. If you feel the need to write, I don't want to be a crybaby or I don't want to make excuses, I take responsibility, but I also want to, clear this is how racism has affected my life, my upbringing, community, pleading for this crime after whatever's important to you. I think it's totally fair game, and the readers do understand and take it seriously. And if you had like an all-white jury, you should tell them that. They get that.
Yeah.
And I definitely talk about those issues in the petitions we work on, and I talk about these issues with the governor's office in general. So absolutely.
Thank you so much for that answer.
Sure, my pleasure. Hi, I can see you.
All right. So my question has to do with the non-unanimous verdict Ramos case. So I'm in the process of that. I filed for post-conviction, and I want to go home. So if I file for clemency and I'm in this process, it's not so much about me wanting to go home. I know a handful of people that are in prison right now by a non-unanimous jury verdict. So my question is, can I still file? And again, I wanted to say this one more time. It's not just about me going home. It's about the fact that I'm not supposed to be here in the first place. So what is that?
Mm-hmm. You don't have to tell me that. I know. I agree with you. What's your name?
Bautista, we've talked before. You probably don't remember me.
Hi, yeah. Hi, nice to see you.
You too.
So for people who have a non-unanimous jury conviction, I was going to save this till the end, but it's very brief. As you may know, the U.S. Supreme Court has ruled that there's no retroactivity. However, I don't think we'll truly know what will happen on the issue of whether Ramos applies backwards to cases like yours for people with a known non-unanimous jury in particular. We won't know until either the Oregon Supreme Court rules or there's a chance that we will pass legislation in the coming session. I'm working really hard on both of those. I agree with you. Anyone with a non-unanimous jury conviction should be there in the first place. The governor's office totally supported changing the law on non-unanimous juries. They're interested in clemency cases where there are non-unanimous juries convictions. They believe that it was an injustice. And so even if you have a pending post-conviction case on Ramos, you're gonna just have to leave that and wait it out over the next year to see what happens. In the meantime, if you want to bring a clemency case, and one of the reasons and one of your parts of that is non-unanimous jury, absolutely. So you'll do all the other things that are in the clemency petition, the necessary steps, and then you can have make sure you say up front that you were convicted by a non-unanimous jury. And that's an injustice. And, as of now, Ramos versus Louisiana does not apply to you. And here's why, I'm a great clemency candidate anyway. Right? So again, include both. They totally understand that issue and they believe it's an injustice as well.
Okay, thank you.
I'm Scott.
Hi.
I'm Scott Johnson. First, I want to thank you, Lisa. Not from just everybody, I speak for everybody here when we say thank you so much for everything you do. It's awesome. You're amazing and we love it. We thank you. So I heard you, this is about a detailed parole plan. So for those of us that might have multiple options on what we could do, maybe they're based on different criteria, like if we were to get out this year, maybe we need to go move in with our folks and help them out, or if it's a few years down the road and maybe that thing's not there. If we have multiple options, do you advise to nail one down and go with that, or sort of detail all of them out and sort of explain the criteria for each one? And then I have a second part to that, not to that, but a second part question is, if you have any visibility on the success rate of the pardons and the clemencies, the 33 and the 32, is that a really high success rate? Thank you.
Both good questions. Thank you. So first of all, a detailed parole plan, I think you should focus on sort of if I got out within a year. That you should nail down a really detailed plan, like as if she read it and you went through the 6 month to 1 year process, and then you walked out the door, right?
Okay.
What would that look like? And, you know, obviously, it's hard to know because you don't know if you're getting out. It's hard to know what to put there. The main thing that they want to see is that you thought about all these things, right? And you can't, what I would do is put a really detailed one as if you were getting out within the year. And then you can say, you know, depending on timing, you know, there might be some update. And the truth is, when the governor grants, and Nathalie and Michelle will, I'm sure, support this, then we start looking what's the deal. You know, okay, they're getting out now. What is their plan, right? And we go back to what they wrote in the petition, and we see all these things, and if any of them don't fit anymore, we address it. So it's really important to the governor, as Nathalie mentioned, that she wants people to be successful in their community. So she wants to make sure you have a good plan, especially housing and some support. So I would plan for, you know, writing it as if you're getting out in a year and making it as detailed as possible. You could make notes that says, you know, something little like, if the time were different, I might have a job here, or I might have responsibility here, but it's better not to be too wishy-washy and just come up with a good plan. And then, you know, and then if and when you get muted, yay, then we can all go back and look at your release plan and really tighten it up, because it'll be happening, right? And people's lives change. You know, everything changes, especially when you don't know a date. You know, we often have people housing and then it falls through, and we got to work on that. And we will, in the time, you know, usually have at least, you know, a number of weeks or months before you actually get released, even when you're granted. So that's that. Does that answer your question on that?
Yes, thank you.
Okay, and then I think the other question, you had one more question, and I forgot what it was.
Success rate.
Oh, success rate.
Visibility on the success rate.
Success rate
Yeah.
with those numbers.
Okay, my students are in here whispering success rate to me. They were listening better than me. Okay, so, you know, what I would say is if you look around the country, there's about 3 or 4 governors right now that are incredibly open to clemency. Half of them are more low level, COVID, or just, you know, getting people out that haven't committed serious crimes. I think there's only 1 or 2 governors besides Governor Brown that are looking seriously at people who've committed serious crimes, and that are really sort of making a dent in it. So I would say that what she's done over the last year in particular, between COVID and these individual cases, is, first of all, extraordinary for Oregon, because the last few governors, the last governor did, I think, 1, and you know, he was the governor 10 years over it all, and I think he only did 1 or 2. So that's pretty amazing. And I think that while she might have a little competition in a couple other states, in general, I think it's amazing. And I will tell you, I absolutely think there's a lot more to come over the next year and a half. I can't be sure. You know, she's the decision maker, and that's what we all have to remember. But I know I'm working on a bunch of different cool things that I'm hoping she's going to be receptive to.
Yeah.
I'm sorry,
Talking
ladies.
to this one.
I totally screwed up the question. What I meant was, like, in terms of success rate, like the
How many were
recidivism.
filed? Or
From what she gets in her office.
Well, no, like for guys that get it, when they get out, are they coming back to prison?
Oh,
or are they
recidivism.
staying?
I get it
I'm
now.
sorry,
I was thinking the same thing.
No,
Recidivism.
I didn't understand. Okay, so when people get out, what's their success rate?
Yeah.
Okay, so I'll tell you, in my entire career, over 20 years of helping folks get out of prison all over the country, I've only had 1 person reoffend. And that's pretty amazing. And, you know, don't clap for me, clap for them. They're doing all the work. I will say that, reentry is really hard. I would never even claim to understand it. I know that it's not just important to have a good release plan for the governor, it's really important to have a good release plan and support for you if you're getting out, because it's a lot. And even people with tons of support, need even more than that, right? So, I just feel like I feel so fortunate that in the 20 plus years I've been doing this kind of work, in many different states, that, have been really lucky. And I think that part of the reason why I like working with lifers, especially, is because I feel really strongly on the success rate, and I feel really strongly that so many of you will succeed. I feel really good about that because you've done the work. So, so the success rate in Oregon is very, very good.
Awesome. My question, Eliza, hi, this is Kyle Hedquist. Hi, is relating to guys that are either going to see the parole board soon, or guys that have seen the parole board and have gotten flopped. There's been a lot of questions to me, as in, like, should they file if they're getting ready to see the parole board imminently just to get it filed, or should they file immediately after they get flopped? So can you explain a little bit what your take is on guys with the parole board?
Yeah, so first of all, if you have a parole hearing in the future, and you're applying for clemency, you should say, I would like to be commuted out for release, or in the alternative, I'd like to go to the parole board earlier. I think it's really important giving her the option, because she likes that option a lot. So if you have a number of years before you're supposed to face the parole board, maybe you haven't gone yet on your first 25 or whatever, and you're a few years away, ask her to send you early. Because the truth is, the parole board is often looking for very similar things to the governor. So if you're a good candidate and the governor says, I've read all this and I'm not going to release them, but I'm going to send you to the parole board a few years early, then you just take that clemency petition, we turn it into materials for the parole board, right? You have to do a few more things. And then you're also going to the parole board with the board knowing that the governor supports you, right? So if you haven't gone yet and you're making an ask for release, and you have a parole, even if you just have a really long sentence and you don't have a parole board hearing coming, ask for that as an alternative. It's much easier for the governor to do that if she's not sure, or if your DA or victims don't agree. Give her an alternative. For people who have one coming up like any minute, like within the next year, it's a hard call, because you really can only file for clemency for another year plus, right? I would say get it in and then use the same materials and go to get ready for the board at this point. Probably, if you asked me a year ago, I would say go to the board first and see what happens. But I think because of timing, since so much of the materials are crossover, just get it all in and use some of the same stuff for both. If you just got flopped, you can apply. I have a client who got out and like 2 months after she got flopped. So, and I know people who got out before they even get to the board. So both are, I would say, do everything now.
Awesome.
Does that answer?
That's a great answer. I got one other question. So will the governor only consider what you ask for in the clemency packet?
Great question. I would say, I think yes. And, I had a youth that we asked for this spring, where we asked her to send him to the work camp out at Florence for 6 months before release. And he came up with that. He wanted to do that. And then she finally got to his petition, and it's like a year later, and he said, I just want to get out. And I said, yeah, but she's going to send you to the work camp because you made such a good case for it. And that's what she did. So I think that really good to give alternatives, to always ask for release, because you might get it, right? But then say in the alternative, run my sentences, concurrently, or send me to the parole board. I've had cases where I've asked for 3 things, put them all in there, can't hurt.
Okay, cool.
Thank you.
Thank you.
Thank you.
Good afternoon. My name is Raymond Eddings. If I could, I have 2 questions. The first question you touched on was serving at least half your sentence for clemency. What about those of us that are doing life without parole? Is there a minimum date for that? On how long it could be?
Yeah. So that's a really good question. I don't know exactly what the governor would say, because I've never talked to her or them about that. I would say if you have LWOP, first you should definitely ask in your clemency petition, obviously ask for release, because why not? But you're definitely asking to go to the parole board.
Okay.
That's the ask, right? And I would say, she's granted people that have, I think of it like if you have LWOP, that like you could have gotten 30 years, you could have gotten 25 years, if it was a different moment in time, right? So I feel like if you served 15 to 20 years and you're an LWOPer and you meet all the other criteria, why not?
Okay. My second question. My second question has to do with multiple convictions. So Oregon has a bad habit of shotgunning effects on the indictments and on convictions. So in my case, I have 10 convictions, but only 1 docket number. How do you address all those convictions when they're all like that, or do you have to?
You have to, for the sake of just being open and putting everything there. I think it kind of depends. Every case is a little different, but if you have 10 convictions, and are they all concurrent?
No, they run them consecutive.
They're consecutive and they're
Yes.
LWOP. You have to talk about it.
Yeah, there was 10 convictions and only 2 instances. And
then I would say, because you're right. I mean, the overcharging and the stacking and all that, I get it. So I would just explain that and say, I know I have 10 convictions. They're all related to these 2 events. And your ask is to be commuted out or to the parole board, right, if you're LWOP, for all of it.
okay, thank you very much.
So the good news is, because of time, there isn't that much to talk about with 819 at this moment, because it's so new. But I know there's a lot of questions, and I just I've gotten a bunch of letters about it, and I'm basically sending the same blurb. So if you write me right now, I'm just going to send you the same blurb, because I don't have much more to say. But what I do want everyone to know is why the clinic sponsored this bill. Senate 819, which was just passed by the legislature and signed by the governor, it's going to go into effect January 1st. It basically creates a procedure for people convicted of and sentenced for felony offenses, any kind except ag murder, because of constitutional reasons, to have a reconsideration of their conviction and or sentence in the original sentencing court. The catch is, and this is going to be a big catch for a lot of people, is that the district attorney from your county has to join you in the motion. So I'm getting already letters that say, how could you agree to such a bill and all this stuff? Well, I helped write it and I agreed to it because we need as many avenues as possible to get people out of prison. Right now, because of mandatory minimums, we are limited to clemency, right? And so we gotta create as many options as possible. We do not know who the next governor is gonna be. And whether there'll be any clemency, in the next years after Governor Brown. Hopefully, yes. Hopefully she's setting some precedent, but we don't know. So to me, even having not perfect mechanism is better than having nothing. So 819 requires a person, and the legal standard is school in the interest of justice. And so, California and Washington both have a similar law, and it can be used for people with wrongful convictions, to get rid of their conviction entirely, right? Imagine if you are wrongfully convicted and innocent, and some new science comes out and can prove, and I don't mean DNA, but where we've debunked some old science that was used to convict you, and you have no way of getting back into court. This would provide an opportunity to team up with the DA, say to them, hey, do you know that we don't use bite mark evidence anymore to convict people, that it's a bad science and no one should be convicted of that? Let's go back to court, right? So there's that whole side of it, deal with wrongful convictions, an avenue for people that have new evidence and can prove a wrongful conviction. And then there's a whole interest of justice related to excessive sentencing and rehabilitation. And the statute lays out examples that the court may consider when looking at a motion. And those are all very similar to clemency. Rehabilitation, age at the time of the crime, age at the time of the petition, mental and physical health, right? During COVID, many of us felt like we had no avenues besides the commutations that the governor was doing. There was no avenues to take people out of prison, people that were dying. This would be an avenue for that. This would also be an avenue if we can prove some kind of disproportionate sentence between counties based on race, right? That would be another reason why we could go to the DA and ask them to join us. And so there's a lot of possibility here. Obviously, DA has to be interested in your case. I will tell you, I work really closely with the new DA in Multnomah County on this, and we're going to continue to work together on this as we move towards January and beyond. We're working with them to create their materials and criteria. If the clerk is hopefully going to be working on cases with the applicants to bring Multnomah County. There's also 2 or 3 other DAs who have reached out and told me they're interested. And I do believe under the right case, other DAs will also be more open than people. So we don't know yet any details how to apply for this. That's the main thing people want to know. How do I apply? It's going to really be up to the DA's office, each county, to decide that. But I am working with Multnomah County to create an application sort of process. We will offer it to all the other DAs. I don't know if they'll take it. And then it's up to the DA's office to create their own criteria. What are they interested in looking at? What will, allow them to go into court or be interested in a particular case? So it's going to really vary. And because January, thankfully, is a little far away, so we have some time, I would say the clinic will have more information in another couple of months. And when materials are available, either for all the counties or individual counties, I will make sure that they go through Nathalie and Michelle and get into the law libraries. 100%. We've also been we will put information in the Lifers newsletter and a couple other places where you can get information. So that's what it is right now. I'm really excited about it. But, I don't have the details of process yet.
Hi, Elisa. It's Raven.
Hi, Raven.
I wrote to you a couple of times. You say on this new bill, everybody except ag murder. So what about us people that are doing ag murder, but because the new 1013, if we wouldn't have been ag murder now, we'd be either murder 1 or murder 2. What's that? Is there anything that will apply to us, or we just kind of?
It's such a good question. First of all, obviously the first draft of this had ag murder in it, and we were told by legislative council that it violated the Oregon Constitution, and so, which I do understand. When I went back and looked, I did understand that. But so it is a real shame that it is not included in this. Honestly, this is exactly what I was saying. For people who have ag murder, for people who have LWOP, or mostly, right, ag murder folks, your option is clemency and trying to get yourself to the parole board. And unfortunately, 1013, I know there's some litigation on it, we don't know the ins and outs of it, but as of this minute, it is not retroactive. Just like 1008 for the youth was not retroactive. And obviously, almost right now is not retroactive. Obviously, I disagree with all of that. But right now, if you do have an ag murder or an LWOP, and you are, as amazing as we know all of you are, then your bet is to go Clemency and do it soon.
Aliza, what's up? It's Sterling. How are you?
Hi, Sterling. It's so nice to see your face.
Thank you. Oh, it's good to have
And I know I owe you a phone
Yeah, I don't
call.
hear that much, right? No,
First time?
I know, first time, huh? So it's a little abstract, but I think we've spoke about it a little bit. So we've clearly seen, and thank you too to Nathalie, especially for the donuts and all this other stuff, and thank you to you. But
Wait, I'm missing donuts?
yeah, we got some donuts.
Yeah, not okay.
No, completely okay. It's so we've seen since we've seen this increase in commutation, we've also seen like such a high level of motivation. Like, I mean, the hope is visible, right? Like, you got cats that never cared about their health, now they're working out, exercising. People that have never thought about the dysfunction that brought them to prison are now trying to understand it so that they could explain it. So we see the motivating value of hope, but yet we also know that this is such an extraordinary remedy. And although we see people in these positions to where the system is changing and going in a new direction, what would you suggest for people to, knowing that it's an extraordinary remedy, how do you keep that hope alive? Like, how do you keep encouraging that? What would you suggest people do? Like, we hear Raven and we hear some other people that might not fit in these little bitty categories, but what would you say to them to keep doing, knowing it ain't guaranteed, but we're moving in the right direction? Could you speak to hope, basically, is what I'm trying to ask.
Oh, you're so good to me.
Thanks.
Sterling knows that hope is like, hope is what I think about all the time. And I'm always caught between all the work that we do here in the clinic. I don't want to create over hope. And we feel pressure. We want to help as many people as possible. But it's been explained to me that it's a good thing to have hope, even if you don't have all the answers all the time. So, and Sterling and I have talked about that a lot. I guess what I would say, and I can only really speak from my 20 plus years of doing this kind of work, is that, I always have some, right? And I know I'm not doing the time, and it's really different, but and my students will tell you this, I'm a yes person. I am always looking for new avenues for folks to be able to bring their claims. And I think we're really fortunate in Oregon that, I always say the pendulum swings. And our pendulum in our Department of Corrections, in our legislature, it's really different place than it was 10 years ago, and it's in a really different place than it was 20 years ago. And there's a lot of people that really care about the fact that so many of you are inside, that there's so many injustices in our system. But it also takes time, whether it's to pass new laws, to think about things differently, to change culture, right? And so all we can do is keep cracking at it, keep going after it. And that's why I said, like 819 doesn't apply to everybody, isn't perfect, you need the DA, but if it's gonna help me get, 20 more people or 100 more people out of prison, I'm down. That's great. That's what I want to do. And so the question is, what can we all do to keep the hope going and keep coming up with new ways to both work on our individual selves and work in community to come up with new ways to, get the people who no longer need to be in prison right? But are still sitting in there. How do we get great options to get you out of there and to get you having, a different life? And I tell people, anyone who will ask, I tell them there are so many people sitting in Oregon prisons all over this country that really, in my opinion, do not need to be there and have done everything right and well. And we have to really decide what are our goals now, not what were our goals at the time of your conviction and sentence, because it's changed and we've evolved and we have new ideas. So I'm here, I'm doing it, I'm gonna keep fighting for different things, and I'm always open to people's ideas. And I do think that even though the measure of open laws passed this session, I think it was incredibly encouraging that we were having the conversation. That hasn't happened before, right? And if you speak to Senator Clemency, he'll be the first one to tell you he's not giving up. So, let's hope our next governor is really interested in clemency, that this governor is setting precedent, that this governor is going to do a whole bunch more over the next year and a half. Let's hope for that. And I know that everyone in this room, from everything I understand, whether I know you personally or not, you're all amazing candidates for clemency. So I would definitely consider submitting. And for other people who are going to watch this, please read the materials and see if you think you are. I hope that answers it a little bit. It is abstract. It's obviously something I think about all the time. So.
Thank you.
What are your feelings on that, Lisa, before you go? On Governor Brown, do you feel like she's gonna do a bunch before she goes?
Yeah, again, I always like to be clear. I am not Governor Brown. I don't know what she's thinking. I don't know what her plans are, but I do believe she's committed to this. I believe she's already done a lot in the last year between the COVID and the individual cases. I know her office is reviewing them like crazy. I'm working in my clinic on a couple different groups of cases, so we can kind of make policy. We're asking for policy changes, which we don't know if she's open to those or not, but we are working on a bunch along with individual cases. I know a whole bunch of my former students are working on cases, and we all feel very positively that there's a lot more granting will be happening in the next year and a half.
Thank you so much.
That's my opinion, but yeah. Thank you all so much.
Thank you. And your staff.
I can't wait to get to come back in and see all of you.